Welcome, everyone. I'm excited to begin our journey today exploring the rich diversity of legal interpretation within the Islamic world. On this first slide, we have the title, The Schools of Muslim Law, A Journey Through Islamic Jurisprudence. Over the next few slides, we'll delve into how different schools of thought shape Islamic law and understanding. So let's get started and uncover the fascinating nuances of Islamic jurisprudence together. So let's talk about how Islamic law derives rulings for new situations. One key method is called qiyas, or analogy. This involves comparing new issues to established precedents found in the Quran and Sunnah to reach a fair and reasoned conclusion. Another important concept is ijma, which is the consensus of the Islamic community or scholars within a specific era after the Prophet. Ijma helps us establish binding rulings on matters that aren't explicitly addressed in the primary sources. Then there's the Sunnah, which includes the sayings, actions, and tacit approvals of Prophet Muhammad. The Sunnah provides practical guidance for applying the principles found in the Quran. And of course, the Quran itself is the literal word of God, revealed over 23 years to the Prophet. It remains the most authoritative source of Islamic law. All of these elements come together to form Sharia, a comprehensive system that guides every aspect of a Muslim's life, from worship and daily conduct to family and financial matters. These principles work together to help us understand and apply Islamic law in a consistent and meaningful way. Now, let's take a closer look at the four major Sunni schools of thought and their key features, starting with the Hanbali school, which is known for being the most conservative. It relies heavily on the Quran and Sunnah, while minimizing the use of analogical reasoning and independent opinion. This school is primarily influential in Saudi Arabia, especially among those who follow the Wahhabi interpretation, and also in some Gulf states. Moving on to the Maliki school, it's recognized for its systematic and methodical approach to jurisprudence. Malikis carefully rank their sources and place less emphasis on analogical reasoning, focusing instead on the practices and traditions of the people of Medina during the Prophet's time. This highlights their view that the living practices of the community serve as a vital source of law. The Maliki school is prominent in North and West Africa, Egypt, and parts of Arabia. Next, the Shafi'i school emphasizes the practices and traditions of the people of Medina during the Prophet's lifetime, considering these practices a living source of law. They follow a methodology that balances the Quran, Sunnah, and consensus, with a particular regard for the customs of Medina. This school is widespread in Egypt, Sudan, and across Southeast Asia, including Indonesia and Malaysia. Finally, the Hanafi school, which is the largest of the four, making up around 85 to 90% of Muslims worldwide. It's known for its flexibility and reliance on analogical reasoning, qiyas, and independent legal reasoning, Rai. The Hanafi school's approach is more liberal in methodology, which has contributed to its broad geographic reach, including Turkey, Central Asia, Pakistan, India, China, and Iraq. All four schools apply the same core sources, Quran and Sunnah, but they interpret and prioritize these sources differently, which reflects their unique methodologies. This diversity enriches the overall tapestry of Sunni jurisprudence, helping us understand how different communities practice their faith in varied contexts. Let's start by talking about a significant minority sect within Islam, led by the Aga Khan. You'll find this community mainly in Pakistan, parts of the Middle East, and across East and Southern Africa. They're particularly known for their emphasis on esoteric interpretation, meaning they focus on deeper, inner meanings of religious texts rather than just the literal words. This school is called the Ismailiyya school, and it's quite unique in its approach. Moving on, the largest Shia school is the Twelvers, also known as the Ithna Ashari school. This branch serves as the official religion of Iran and is also widespread in countries like Iraq, Lebanon, Syria, and Pakistan. One of their core beliefs is in 12 divinely appointed imams, with a special emphasis on the 12th imam, who is believed to be in occultation, meaning he's in a hidden state, but still very much a part of their faith and future hope. Next, we have the Zaydiya school, which is the second largest branch of Islam overall. They account for about 10 to 15% of the Muslim population. The Zaydis developed their own schools of jurisprudence that incorporate the teachings of the Imams as authoritative guides. While they share some similarities with Sunni jurisprudence, they also maintain distinct theological positions, making their approach to Islamic law quite unique. So, as you can see, these different schools of thought highlight the rich diversity within Shia Islam. Each has its own beliefs, practices, and interpretations, but all contribute to the overall tapestry of Islamic thought we're exploring today. Today, I want to highlight an important aspect of Islamic inheritance law, which is that 2/3 of an estate are subject to fixed Sharia inheritance shares. These shares are not something that can be altered by will or testament, meaning they are divinely ordained and must be followed precisely. These shares are calculated mathematically, ensuring fairness and clarity according to divine guidance. Next, let's talk about lifetime gifts. Generally, if someone makes a gift during their lifetime, it's permitted without restrictions or concerns about clawback. Once the gift is properly transferred, it becomes the property of the recipient, and the giver cannot reclaim it later. Now, what makes Islamic inheritance law particularly distinctive is the science of fixed shares, known as Ilm al-Faraid. This system is one of the most precise and mathematically rigorous parts of Sharia. It guarantees that wealth is distributed fairly and according to divine prescription, which is a core principle ensuring justice in inheritance. Finally, I want to connect this to our overall theme of succession principles. These rules form a solid foundation for understanding how inheritance functions within Islamic law, emphasizing divine justice, mathematical precision, and fairness in wealth distribution. When it comes to bequests that exceed 1/3 of the estate, the heirs-at-law must give their consent. For Sunni law, this consent is required after the testator's death, whereas Shia law allows the heirs to give their consent either before or after the testator passes away. This difference highlights the variation in how each tradition handles the influence of heirs on testamentary dispositions. Moving on to the scope of consent, in some Sunni countries like Egypt, Sudan, and Iraq, bequests can be made to both heirs and non-heirs, but only with the heir's approval after death. In contrast, Shia law generally permits bequests to both heirs-at-law and non-heirs without such restrictions. Now, let's talk about beneficiaries. Islamic law places limits on how much of the estate can be freely bequeathed. Usually, this freedom is restricted to 1/3 of the estate, and this amount is calculated after paying off debts and funeral expenses. This approach strikes a balance. It allows some personal choice for the testator while ensuring that the majority of the estate goes to fixed, predetermined shares. This concept of 1/3 bequest is a key point because, although Islamic law prescribes fixed shares for heirs, it also recognizes a limited degree of testamentary freedom. This balance aims to respect divine prescriptions while allowing some personal discretion. So, in summary, testamentary freedom is not unlimited. It's carefully balanced by religious principles and legal rules to protect heirs, rights, and maintain social order. Generally, inheritance rights cannot be transferred or sold before death. However, in some jurisdictions, it may be possible to contract not to claim a right through advance agreements. When we look at the transfer of rights, the Shia view is that you cannot inherit from either parent. This reflects their different interpretation of lineage and legitimacy. On the other hand, Sunni Muslims can inherit from their mother, but not from their father. Now, regarding illegitimate children, non-Muslims generally cannot inherit from Muslims through intestate succession. This is because inheritance rights are closely tied to religious community membership, which influences who can inherit from whom. When we consider non-Muslim heirs, it's important to understand that Islamic inheritance law has specific rules about who can inherit and under what circumstances. These rules are rooted in both theological principles and practical considerations, ensuring the system functions fairly within the framework of Islamic law. All of these points tie back to the overall theme of understanding how inheritance laws are structured, highlighting the nuances and variations based on different beliefs and legal contexts. Let's delve into how Islamic law approaches inheritance by examining the principles derived from Quranic amendments and the sayings of the Prophet. These principles are integrated with pre-existing laws to create a more comprehensive system. Generally, Islamic law aims to place relatives through women on equal footing with those related through men, reflecting a move towards greater fairness. Additionally, the law is more liberal when it comes to bequests to heirs-at-law, allowing for some flexibility. Another important point is that consent regarding inheritance can be obtained either before or after death, providing more options for involved parties. Now, shifting focus to Shia law, we see that it evolved from pre-Islamic customs but was later modified by Quran and Sunnah. Shia inheritance tends to favor male lines of descent and ascent, emphasizing agnatic relatives, those related through males, more heavily. The rules here are more restrictive concerning bequests to heirs-at-law, and importantly, consent must be obtained after death. In contrast, Sunni law, as we'll explore in Chapter 7, follows a different path with its own set of principles. Overall, understanding these differences helps us see how these legal traditions shape inheritance practices within the Muslim community, aligning with their theological and cultural contexts. Let's take a moment to discuss some practical legal considerations when it comes to applying Sharia principles in the United States. First, it's important to note that while some states have enacted anti-Sharia legislation, federal courts generally uphold the right to probate wills according to religious precepts, as long as those wills don't violate public policy. This means that, within legal limits, Muslims can structure their wills to reflect Sharia inheritance rules. Trusts and other estate planning tools can be used effectively to allocate fixed shares and testamentary bequests, ensuring their wishes are respected. Moving on to marriage and family law, Islamic marriage contracts, or nikah, are recognized when they meet state marriage requirements. Additionally, prenuptial agreements can incorporate Sharia principles, provided they comply with constitutional standards. This flexibility allows for respecting religious traditions while adhering to state laws. Finally, Sharia law does have domestic applications, especially in areas of private law. Here, religious freedom intersects with state legal systems, allowing Muslims to navigate legal matters in a way that honors their faith without conflicting with broader legal standards. Overall, understanding these practical applications helps us see how Sharia principles can coexist within the legal framework of the United States, supporting religious practices while respecting the country's legal boundaries. Let's take a moment to reflect on the principles of inheritance in Islamic law. While these principles are fundamentally rooted in divine sources, it's important to recognize that they are not static. Over centuries, various schools of thought have interpreted and applied these principles in nuanced ways. This diversity reflects the rich scholarly tradition that has developed around Sharia, adapting to different cultural contexts and legal environments. Understanding these differences is crucial, especially for legal and estate planning. When working with Muslim clients, being aware of the particular school they follow helps ensure that we are respecting both their religious obligations and secular legal requirements. These schools collectively form a rich tapestry of interpretation, demonstrating how Islam's legal framework has remained dynamic and adaptable through history. In summary, appreciating this diversity in Islamic jurisprudence is essential for providing informed, respectful, and effective legal counsel.